Hi there. Welcome to Money with Mark Albert. Today we're going to look at the concept of what it means to die intestate. So to die without a valid will. So if you don't have a valid will and you die, what's going to happen? So we're just going to cover at a really high level. We're going to understand some terms, and we will talk about, what about if you die and you're married without a will, or if you die in your common law without a will, and the implications of that. So what I want to do now is share this screen, and I put some notes, and we're going to look at that together. We're going to walk through this, and hopefully you'll find this beneficial. So the term dying intestate, we'll look at that. So basically, we need to understand what a will is. It's a legal document, and it disposes of a person's property on or after that person's death. Now, the will sets forth your wishes regarding the distribution of your property, as well as the care of any minor children. Therefore, if you die without a will, those wishes may not be carried out the way you would desire them to be. So what does it mean to be testate? Well, testate, it's not a term we use every day. All it is, it's a person who dies with a valid will. So if you die, your will is valid, then you die testate. So the word intestate is basically the same thing, except it's dying without a valid will. So the person who dies without a valid will is said to have died intestate. And so dying intestate create some challenges. Today, we just want to talk about how your assets get divvied up. So dying intestate is the person who dies intestate actually has a succession plan. So if you die with a will, right, we talked about your wishes. You can set forward your wishes in a will. Therefore you have a plan. But if you die without a valid will, you still have a plan. It's a succession plan that is prepared by the government. So the government issues that plan. They have a set plan, and the plan determines who will inherit your estate, how it gets divvied up. And so most of us, we want to determine what we want to happen with our things, the things that are precious to us after we die. And so the government will set that out. So when we die without a valid will, the plan that is set out in the Intestate Succession Act is actually governed. It governs the order of descendants entitled to inherit from your estate. So basically, they have a plan. The government has a plan. If you don't have a valid will, you don't have a say, and it gets divvied up according to their plan. So when looking at definitions under this Interstate Succession Act, which governs this on your behalf, you will see that certain provinces like New Brunswick, Newfoundland and Labrador, Ontario, PEI, they do not recognize common law partners under the intestacy legislation. So if you are a common law in that relationship and you do not have a valid will, then you basically are omitted from the estate of your partner. So let's look at this right here. So in Ontario, all right, well, this is the general rule here. So this is the order in which it gets divvied up according to the act. So if you die and you have a spouse, now spouse here is married. It does not include common law. All right, so if you're married, your spouse and your children, your estate is divvied up between them. It doesn't all just go to your spouse like you could if you had a valid will. So if your spouse needs the resources your spouse won't get all the resources because it's divvied up between your spouse and the children. So let's say if you have no children and you're married, then it goes only to your spouse. If you have no spouse, then all goes to your children. If you have no spouse and no children, then it goes to your parents. And let's say you don't have any parents either, no spouse and children, then everything goes to your brothers and sisters. And if none of the above are around, then it goes to your nieces and nephew. Okay. If none of the those above, then it goes equal to the next in kin. All right. Now, in the event that there are no heirs, then the estate passes to the crown. So the government gets everything. All right. So, you know, if you die without a valid will, you basically, everything's in the control of the government in terms of directing your assets. So I just want to say, you know, common law spouses are not treated the same as married spouses under the law specific to this estate planning type of concepts that we're looking at. And they do not automatically have the same property rights either. So if you are common law and you own a house, or you're living in a house and you're common law, but you're not on title, then you don't have any rights to that property if the spouse, the common law spouse who dies, was the one on title. Then the house gets divvied up according to the rules of which we looked at just now. So in Ontario, if a common law spouse dies intestate, the surviving spouse will not inherit any part of the estate. They are completely omitted. So let's look at here. So this is how it gets divvied up. If, let's say, it's between a spouse, like a married spouse in Ontario, and they have children. So they have this preferential amount for the spouse. So the first 200,000 goes right to the married spouse who is left behind. So let's say the estate was $1 million that was left behind. So 200,000 would go to the spouse. Then there's 800,000 left over, right? So half of 800,000 is 400. So 400 more goes to the married spouse, and the other remaining 400 to the one child. So if they have, let's say, more than that, so let's say they have two children, 1/3. So the first 200,000 goes to the married spouse, and then 1/3 goes to the married spouse, and then the remaining 2/3 of what was left over goes to the children. So this could be a problem if, let's say, you are married and you don't have a valid will, and there's $2 million worth of an estate that's supposed to go to your spouse. That spouse will get the first 200,000 of the 2 million. So then there's 1.8 million left. And so of the 1.8 million left, they're going to get, your spouse is going to get 600,000. And the remaining 1.2 million is going to be split between the last two children. Okay. So this is very important stuff. And as some things from an estate planning standpoint, it's good to think about. Listen, trust that you're doing well. And if you have any questions, please comment below, and that'd be great. Listen, have a great day, and we'll talk to you later.